Be ready. 5 seconds to go. On the other hand, it is the case of the respondent as acceptance was not unconditional. It does not amount to a binding contract between the appellant and the first respondent. As such, the arbitrator has no jurisdiction to decide lies between the parties. Mainly, it was a case of the appellant that as much as the acceptance of the bid will conclude the contract and having regard to terms and conditions of NIT and general conditions of contract, it is a binding contract between the parties. As such, dispute is to be resolved only by way of arbitration. The learned counsel for the appellant has placed reliance on judgment in the case of Governor Cementation India Limited versus Bajrang Lal Agarwal and another. It is a case of the appellant company that even if the first respondent disputes the jurisdiction of the arbitrator, it is open for the first respondent to move an application before the arbitrator under section 16 of the act, but at the same time the suit filed by the first respondent for declaration and injunction is not maintainable. In the judgment of this court in the case of Governor Cementation India Limited versus Bajrang Lal Agarwal and another, this court has examined the similar issue and held that any objection with respect to existence or validity of the arbitration agreement can be raised only by way of an application under section 16 of the act, and civil court cannot have jurisdiction to go into such question. Having regard to aforesaid judgment of this court and various communications between the parties, we are in agreement with the submissions made by the learned senior counsel for the appellant that if the first respondent wants to raise an objection with regard to existence or validity of the arbitration agreement, it is open for the first respondent to move an application before the arbitrator, but with such plea he cannot maintain a suit for declaration and injunction, though the trial court rightly rejected the interim injunction sought for by the first respondent. The same is erroneously reversed by the learned additional district judge, and such order is confirmed by the High Court by the impugned order. As we are of the view that the order passed by the additional district judge and the High Court are not in conformity with the law on the subject and are contrary to judgment of this court as referred above, the impugned order is liable to be set aside by vacating the injunction orders.